Hello everyone and welcome back to the channel. This is Snigdha Mohapatra, a third year student from KIT School of Law and currently an intern under LEXCLIQ. In the previous video, I talked about a very important concept under the trademark law, that is passing off. In this video, I will be talking about the difference between passing off and infringement. Prima facie, both the terms may seem similar, but there is difference between passing off and infringement. The registered trademark holders have a remedy to get injunction and damages caused by the defendant by using deceptive, similar, or identical trademark to deceive or cause confusion amongst confusers. But the remedy of infringement is not provided to the unregistered trademark holders. The difference between infringement and passing off has been identified by the Supreme Court in the case of Durga Dutt versus Navratna Pharmaceuticals Laboratories. As while an action for passing off is a common law remedy, being in substance an action for deceit, that is, passing off by a person of his own goods as someone else's goods, it is not the gist of an action of infringement. The action of infringement is a statutory remedy conferred on the registered proprietor of a registered trademark for the vindication of his exclusive rights to use the trademark in relation to those goods. The use by the defendant of the trademark of the plaintiff is not an essential in an action of passing off, but is the sine qua non or absolutely necessary in the case of infringement. In the case of infringement, the use by the plaintiff is not necessary, but in the case of passing off, the plaintiff has to show usage by which lead to grow its reputation and goodwill. In an action for infringement, likelihood of actual sale by the use of offending mark is not necessary. If there is an imitation of broad or essential or peculiar features of a registered trademark, it is sufficient to cause infringement. For example, if the trademark consisting of a getup, label, and word has come to be known and identified by a particular word, the use of such word would constitute infringement. While in passing off, it is necessary to prove that an ordinary person is likely to buy goods in a belief that the goods are that of the plaintiff, though it is not necessary to show that the actual sale took place. The burden of proof in case of infringement always lies on the plaintiff. In the case of SM Dichem Limited versus Cadbury India Limited, an infringement action is fail where plaintiff cannot prove registration or that its registration extends to the goods or to all the goods in question, or because the registration is invalid and yet the plaintiff may show that by imitating the mark otherwise the defendant has done what is calculated to pass off his goods on those as those of the plaintiff. Now, there are certain remedies for passing off action. Section 135(1) of the Trademarks Act 1999 lists the reliefs which may be granted to the plaintiff who established his case in the court in case of infringement and passing off are firstly an injunction or restraining to further use of the trademark, and secondly, damages or accounts of profits. However, in the case of innocent infringement or passing off, if the conditions laid down in Section 135, subsection 3 of the Act are satisfied, the court will not grant relief by way of damages other than the nominal damages or an account of profits, but an order for delivery up of the infringing labels and the marks for destruction or erasure. Now, the grant of injunction is a right expressly provided by the Trademarks Act 1999. The rules governing the grant of injunctions in trademark cases are based on the provisions contained in Section 36 to 42 of the Specific Relief Act 1963 and Order 39 Rule 1 and 2 read with Section 151 of the Code of Civil Procedure. In the case of Aristo Pharmaceuticals versus Wockhardt, the plaintiff respondent had filed suit and was granted injunction against Spasmoflexon when it was manufacturing under the registered trademark Spasoproxivon. On appeal, the single judge vacated the injunction, but division bench restored the injunction. In SLP filed in Supreme Court, it was said that it was necessary for the court to allow the parties to lead evidence before grant of injunction by the division bench. In the case of Vander Limited versus Antox India, the Supreme Court said that an interlocutory remedy is intended to preserve status quo, and if such an order is not granted, the plaintiff could not be adequately compensated in terms of damages recoverable in the action. Now, next comes the grant of damages. The grant of damages is an award for compensatory damages to the plaintiff with an aim to compensate him for the loss suffered by him, whereas punitive damages are aimed at deterring a wrongdoer and the like minded for indulging in such unlawful activities. Whenever an action has criminal propensity, also the punitive damages are called for so that the tendency to violate the laws and infringe the rights of another with a view to make money is curbed. The punitive damages are founded on the philosophy of corrective justice and, as such, in appropriate cases, must be awarded to give a signal to the wrongdoers that the law does not take a breach merely as a matter between rival parties, but feel concerned about those who are not party to the dispute but suffers breach, such as the consumers who bought the past of goods thinking it to be the trademarked good. Thank you so much for watching the video. Please subscribe to the channel for further and regular updates.